Ron Poliquin, Delaware Employment Attorney representing employees, DoverLawOffice.com. Today's video is going to focus on why attorneys love wage and hour cases under the Fair Labor Standards Act. Now, the Fair Labor Standards Act is a federal law which basically says if someone works overtime, they're entitled to time and a half. Okay? And the reason why attorneys love this law because it's a very broad law. Okay, meaning it's broadly interpreted. It almost applies to every employer. It means the general rule, barring limited exceptions and exemptions, I should say, is if you work over 40 hours a week, you're entitled to overtime. Hey, who does it apply to? Like I said, it applies to almost all employers, meaning the technical, I'm looking at my computer screen here, so if I veer off a little bit, it requires all employees engaged in commerce or the production of goods for commerce and $500,000 in annual gross sales or business done. Engaged in commerce is broadly defined, okay? Meaning it applies to almost to everyone, okay? Here are some of the exemptions. Commissioned sales employees, computer professionals, drivers helpers, loaders and mechanics, farm workers, salesmen, seasonal and recreational establishments, okay? And the biggest misconception is the salary white-collar exception. There is no white-collar exception, okay? There is an exemption for executive, administrative, professional, and outside sales employees. And these are defined by the Federal Department of Labor regulations, who are paid on a salary basis, okay? But many employers improperly classify employees as salaried. Clerical and administrative jobs are often misclassified simply because they are white-collar jobs. There is no white-collar exemption from overtime. And just because you say someone is salaried doesn't mean they're exempt from overtime. They have to meet two tests. One, the duties test. What are the person's primary duties? Meaning it's not so much the person's title. If you call someone a manager, what do they actually manage? Are they managing people? Are they doing everything for the most part, are they doing things that other people are doing? They just have the title manager. I remember, growing up working at a fast food restaurant, and we had a shift supervisor, and basically he did everything that everybody else did. I don't know why they called him shift supervisor. Maybe they just wanted to give him a title. That doesn't cut the mustard there. Okay, it's what you actually do, not what your title are. There's a duty test, meaning the employee's duties must be executive, administrative, or professional. Job titles and honorary titles are going to be analyzed. At least half the employee's time in each work week must be actually spent in exempt duties. Meaning, like, if most of their time, if 51% of the time they're doing clerical work or secretarial work, then they are not exempt. And employee must be compensated on the second part of that test, the salary test. They must be compensated on a salary basis, but there's all sorts of exemptions to that. And a lot of people are you can't just give someone a salary and say they're exempt. Okay, just because you have a salary out there, listen to me. Just because you have a nice title and salary doesn't mean you're exempt from overtime. All right. And there can be no retaliation. Meaning, if you come talk to me, come talk to an experienced employment attorney, and we write a letter saying, "Hey, this person's not exempt," you cannot be retaliated against for that. I understand the realities of getting an attorney, going up against your boss. That, what I tell people is know your rights, and then you can decide what to do with them. But don't just assume you're classified, or just because you have a salary, or just because you have a supervisor title that you're exempt from overtime. We're talking about thousands of dollars a year. And one of the reasons why attorneys love these cases is, one, the burden is on the employer to prove this person's exempt, okay? And almost every other case, the burden's on the employee to prove something. In this case, if you're exempt, it's burden's on the employer. 2, there's individual liability, meaning the person setting the hours, determining whether someone's exempt or not, can be individually liable. It's a pretty scary thing to be individually liable, but a very good thing if you're on my side as a lawyer that represents employees. 2, you can also get attorney's fees and court costs for these cases, and there's liquidated damages, meaning you not only get what you were owed in overtime, but you also get double that. Okay, that's how they determine damages in these type of cases. Meaning, like, if, let's say, for the last 2 years you were owed $4,000 in overtime, that automatically turns to $8,000 in overtime. All right. So, no matter what anyone comes to my office, I always talk about whether or not they're being their job is they're being owed overtime that they're not getting, because there are a lot of jobs out there, especially small, medium-sized companies, which have the attitude we can do whatever the heck we want. A lot of times are violating the Fair Labor Standards Act. Get your free analysis at doverlawoffice.com. Make an appointment to see me, and we'll give you a free analysis whether or not you're exempt from the overtime laws. Maybe you want to take action on it, maybe you don't, but at least know your rights, and this way you're empowered to act on them. All right, Ron Poliquin, talk to you later. Thanks again.